Good afternoon, everybody. I thought I would focus my discussion kind of from a little bit of a historical perspective on NRDs. I first started to work with NRDs about 25 years ago when I first went to work for Mike Jess at the Department of Water Resources, which is now Department of Natural Resources. At that time, NRDs, and I think a lot of people forget this, did not have much in the way of authority to manage groundwater. Most of their authorities, to the extent they had them at all, was to manage groundwater to avoid conflicts with other groundwater users. And if you think back, there really weren't very many conflicts between groundwater users. So as a consequence, very few NRDs actually had any rules or regs in place to manage water. Most of what they were concerned about was soil conservation and tree planting. So it came as, I think, kind of a surprise to them when LB 108 passed and they suddenly had some additional authorities. That was in the late 1990s. And then in 2004, when LB 962 passed, that ushered in the modern era of integrated management in Nebraska. And what that meant for NRDs was that they now had to adopt rules and regulations by a unique process and then implement those rules and regs. And that meant the development of water management policy and then creating that legal structure to actually animate that policy. And there are generally three types or groups of hearings that you will encounter before a natural resource districts. The first is rule and regulation adoption hearings. I'll talk a little bit about those. Those are generally the actual process of implementing or integrating into law the rule or regulation. The next are variance hearings. So after you have a rule or regulation that's already been adopted and you might have a client who wishes to deviate from those rules or regs, they can pursue a variance. And that is a unique hearing of itself. And then thirdly, if you've got a client who is a transgressor and violates a rule or reg, you'll have an enforcement hearing. And those, if you're a lawyer, are the most interesting. So let me go first to the rule and regulation adoption hearings. These are legislative in nature. I think oftentimes individuals and lawyers also make the mistake of going to these hearings hoping to cross-examine either staff or board members as to why a particular rule or reg is being adopted and what some of the nuances are. They're not that way at all. Again, as a legislative type hearing, they're informational in nature. They're open to the public, and it's simply you or your client's opportunity to present reasons why a rule or reg should or should not be adopted. Now, to be successful in getting your point across and perhaps actually affecting the final product, you should work with individual board members to educate them well in advance of that hearing. There's no prohibition against contacting those board members and explaining your position to them. And to be able to provide them with alternatives. Oftentimes, I think people go to these hearings and are very critical of a rule, but they don't provide any alternative. To be successful, I think you should have some other rule or reg that could substitute, that could achieve the same goal or objective of the NRD, but perhaps in a less expensive manner or less burdensome. Now, there is no judicial remedy. If an NRD simply chooses not to adopt the rule or reg that you desire, you're really kind of done at that point. You have to wait until they actually implement that rule or reg before you really have any opportunity to challenge it in court. Which takes us to variance hearings. As I mentioned, the variance hearings allow you to get permission to deviate from an already adopted rule or regulation. Variances exist for almost all kinds of the NRD rules, the full gamut of them. Some NRDs have variance procedures that are kind of a one-size-fits-all, a single process by which you go before the board and present your information. Several other NRDs have unique variance processes depending on what program you wish to deviate from. So you'll need to pay attention to the rules and regs of the particular NRD that you'll be before. These hearings have a strange mixture of fact, equity, and sometimes law. Generally, it's a matter of going to the mercy of the board and explaining to them what your unique facts are and why it's fair or equitable to give you a variance. In those rare instances where the facts line up with the law, you can actually sometimes convince them that imposing this rule or reg on your client would violate the law, and in that instance get the variance. Those are pretty tough to achieve. Now, I would urge you to think about the precedent that your variance will set. Originally, when NRDs began offering variances, I think they did it pretty ad hoc, and as a consequence, they created some difficult decisions for themselves down the road when you granted a variance for Russ, and then Dan came along seeking a variance for the same thing, but you really didn't want to do it for Dan because Dan's Dan. So these boards began to think it's important to really be consistent to avoid litigation and think about the precedential value of each decision. So you should do some of the thinking for the board. Explain to them why this will be a precedent that is either good or one that will not affect them in the future. And again, typically there's no judicial remedy if they don't grant you a variance. You're kind of stuck with their decision as it is, unless, again, you have that unique convergence of events where the facts and law actually line up for you, and they try to impose that rule. And then at that point, you might have an opportunity to challenge it in court. Lastly, the enforcement actions. These occur when you have a client who actually violates a rule or reg. Now, generally, before a cease and desist order will be issued by an NRD, they'll have a hearing to decide whether to issue that cease and desist order. That isn't universal. Some NRDs will have staff actually crank out a cease and desist order, but others will put it before the board to determine whether that order should be issued. Now, if you have an NRD that's going to give you that opportunity to be heard before the order is issued, you want to take advantage of it. That's your chance to head off at the pass this order that's going to be difficult for you down the road. Typically, those hearings, these are quasi-judicial in nature, meaning the NRD will typically allow you to call a witness, cross-examine them, or examine them, or cross-examine the NRD witnesses to present other hard information or evidence. All of that can be really useful to setting the stage as to why that cease and desist order should not be issued. If, however, it's too late and they've issued that cease and desist order, every NRD offers you the opportunity to go before them and explain why that cease and desist order either wasn't valid or why it should be repealed. And again, those are quasi-judicial in nature. They are not subject to the APA, the Administrative Procedures Act, and I think that's a mistake commonly made by people and oftentimes even by NRDs. They assume that they're subject to the Administrative Procedures Act. I think there's good case law to indicate that that's not the case. Some NRDs have actually incorporated, though, the APA within their rules and regs, so they've sort of voluntarily subjected themselves. So pay attention to that. That's a unique twist. What you are subject to in the event you get a cease and desist order is you can appeal it to the district court, and that does follow the APA process, the appeal process itself. And those appeals are, again, directly to the state district court. If you violate a cease and desist order, an action can be brought against you both civilly and criminally. So that's an important point to raise with your client. Nebraska has a unique provision in its laws as well that allows not only NRD counsel to bring those civil actions, but allows you to put it to the Attorney General's office for prosecution. And Justin, I was trying to think, has there ever been a time when you've prosecuted one of those at the request of an NRD? Yeah, when Dave Cookson used to be at the AG's office, I used to always threaten to take those cases to him, and he never wanted to touch them. So, but it exists in statute, so it's worth keeping in mind that if the AG's office does want to get involved, it saves the NRDs a lot of money in prosecutorial costs, and I think ratchets up the risk element if you are someone who violated that rule or reg. So I promised Russ I would be very brief because he has a much more comprehensive presentation than I do, so I'll stop there. Questions now or later? Later. All right, thank you.
I'm actually primarily a hearing officer for the state of Nebraska, but through some of my associations back west and just some friends, family, and other clients, we seem to run into a fair number of situations where we're transferring water, mostly within the Republicans or the Twin Platte. So most of my comments will be focused primarily on those southwest type of NRDs, but I think they're going to be applicable across the board, especially as it seems to be a march eastward of having allocations, having certified acres. I think it's inevitable that most of the NRDs are going to be facing some of the issues that the western ones are now. So looking west to see how some of these issues have worked out, I think will be helpful to the eastern NRDs as they progress along and becoming more sophisticated in handling these groundwater issues. What I'm going to primarily focus on are what transferring groundwater means and what kind of issues may face your clients. For transferring groundwater, I'm going to focus more on pooling. Dan will talk more about permanent transfers, and then I don't know that either of us are going to spend a lot of time on temporary transfers because that's not something that happens that often. So transfers, what are those? My understanding, they're of course moving the right to pump groundwater from one location to another. They of course are regulated under the Groundwater Management and Protection Act. They can of course include physical movement from one parcel to another, but they can also mean moving certified acres from one parcel to another, or it can mean actually increasing access to that groundwater allocation, assuming that your NRD has allocations for groundwater. All right. Now in particular, only those NRDs with certified acres and acre inch allocations are going to be able to look at these types of transfers. As you probably know, more and more NRDs seem to be certifying their acres, and that's for good reason. That way you can limit where it's pumped, and then if you need to, how much is pumped upon those certified acres. And of course, you can have some limitations on expansion of irrigated acres within your NRD. There are a few that have acre inch allocations, as we've heard this morning. They seem to be increasing in number. And if I were a betting man, the number of places and the number of NRDs introducing and using allocations is going to increase. I would like to touch on one thing at this point, the acre inch allocation and the certification on irrigated acres. I'm not sure that probably a fair number of attorneys would understand it, but it's not a severable property right. I think some prior water law conferences we've talked about that. It seems to be more akin to a license to me. I'm sure there could be some argument about that and probably several law review articles issued about it, but it's something that is really within the control of the NRD. Permanent and temporary transfers. A permanent transfer, and that's one thing that Dan will talk about in detail, will be a transfer of certified irrigated acres from one parcel to another. It's a way to irrigate more on a parcel, especially if someone wants to get rid of some of their certified irrigated acres. Now, something some folks may not be aware of, and it's probably partly because there's few NRDs that allow it, you can actually temporarily transfer acre inch allocations. Some NRDs will allow you to file an application, and you can say, I, farmer A, want to get some acre inches from farmer B for this period of time. I want to get 3 acre inches over 130 acres. And the NRD will have a certain number of requirements that are mentioned here generally, and they'll either approve it or deny it. One caveat that you as a practitioner should know is that you need to read the rules of your particular NRD, and you need to especially speak with the groundwater specialist, the general manager at that NRD. By and large, they'll be very helpful as you move along through an application process for whatever type of transfer you have. One thing I would mention, in addition to increasing depletion rates or other geographic limitations when you're trying to do a transfer, there are some time limitations too, especially when it comes to temporary transfers and pooling. Pooling. The sharing of acre-inch allocations between multiple parcels. The difference between this and temporary transfers is fuzzy at times. This, of course, is applicable only to those NRDs with acre-inch allocations. What it amounts to is you can have 2 or more different landowners agree to essentially average what's remaining of their acre inches within the allocation period for the remainder of that allocation period. That's generally what it means. You better ask your own NRD precisely what their requirements are on that, but I think that's a good way to describe it. If you have a landowner who's getting close to being over on the end of his allocation period, he may wish to consider pooling. And of course, some of those requirements are the same for pooling, or at least similar, and that's don't increase the depletion rate. There's generally geographic restrictions. There's some common operator, common management requirements for all the pooled acres, and then it's only for a limited time period, generally only to the end of an allocation period, but that can vary from NRD to NRD. Now, from a practitioner's standpoint, I think it's important to consider some of the things that your clients should be looking at when they do this. What happens if you pool and the guy who wanted to pool ends up still overusing beyond even what the average allocation was amongst your pooled acres? Sometimes the penalty for overusing can be double or triple whatever amount you overuse, so it can be significant. So when it comes to drawing up contracts for these folks, it's important to have access to everything, because you could probably spend a fair amount of just one seminar talking about exactly who your client is, what you're going to have access to, who you're writing the contract for. This is all fairly new, so I wouldn't say that this is a well-developed area of the law thus far. I'll try to spend the rest of my time zipping through on just some case studies I think that could be applicable, especially if you're practicing down in the weeds. So, the first one that comes to mind is you have a landlord who walks in, he's renegotiating his lease, and oddly enough, Mr. Tenant seems to have used most of the allocation period's acre inches. And so now he wants a reduction in the lease. He's generally not too happy about this at this point. However, I can tell you in the number of leases that I've looked at, both from my own clients and some of the others that we've looked at from neighbors, the word acre inch is seldom in a lease. Even when it's drawn up by a farm management company, I have yet to see the words acre inch in a lease. The problem is, and I mean, what the first question would be, would your tenant be in breach by using most of an allocation? And I could make a great argument, and I'm sure most of the attorneys in this room could make a great argument. No, he had access to 40 acre inches over 4 years. He used 35 of them. He didn't breach anything. He's put your landlord in a situation where he can't grow irrigated anything in that last year of his allocation period, but he hasn't breached the lease. So you need to look at the alternatives for your client. Let's just say there's some fodder out there for practitioners in this area. Just another potential issue, something that Don had alluded to, and that's dealing with those situations where your clients have went to the board and they have not gotten the result that they wanted. You know, there's a reason there isn't that much case law that's come up in this area, at least in my estimation. That's because the NRDs, they're local entities. They're responsive to their local electorate. And this is a good thing. I think the legislature did right by setting things up this way. By and large, the NRD staff will try to work with water users in whatever way possible within their regulatory limitations, and they'll find a way to make it work. So that's one of the reasons this area of the law hasn't developed that much, is because the NRDs have kept the conflicts from happening in a large number of the cases. They've worked things out. But I think as time goes along, and Don has alluded to it, I think Dan will too, as the sophistication increases, as the number of allocations increase in various NRDs across the state, I'm afraid that conflict is just about inevitable. So this is an area of the law where some of the things are not as clear as they could be. As Don had mentioned, you can have situations where the board, or where the staff has not agreed to something. You can go and get a variance hearing in front of the board. How that is handled can be variable amongst the various NRDs. I would talk to the general manager, I would talk to the legal counsel before you filed your variance application. A lot of times they'll let you hire a hearing officer, which might help things work out. It might help at least create a better record. At least my review of the case law is that you're creating your record at that variance hearing that's going to go to district court. So you should try to do as good a job as possible of getting everything in that's evidentiary at that point in the process, because that's what the district judge is going to have to rely upon. I think I'll leave more of this till later on. People might have questions about that. As Dale Carnegie said, the best way to avoid this kind of situation is just not to have the argument. And as I mentioned, read your NRD's regulations. If you don't understand it, go talk to the legal counsel, talk to their general manager. There'll usually be a way to do what your client would like to do, usually. So that's pretty much my part of the presentation. I think you're up, Dan.
Hi, I'm Dan Lindstrom. At least we'll get some pretty pictures while I tell you all again, follow the rules. Find out whose rules you need to follow and then follow them. What I want to do is sort of piggyback on what the last two guys have just talked about, and again, try to deal with some practical aspects of doing transfers of groundwater primarily in how you deal with NRDs in doing so. And so what I want to do here is simply sort of walk you through the process and give you some things to think about if in fact you're representing somebody who wants to be a party to a groundwater transfer and other kinds of transfers. If you were here yesterday, you heard one of the speakers who said he grew up in Elm Creek, that they were going to build an arch at Elm Creek and say, this is the gateway to over-appropriation. And of course, we have a perfectly good archway just down the road at Kearney, and maybe we should just add a display about fully appropriated and over-appropriated there. But in any event, I grew up in Phelps County and went to high school in Loomis, Nebraska, so I add my name to the list of small-town attorneys that you've heard from today. We all are out in that part of the world have had some experience already with fully appropriated and over-appropriated designations, and that has affected, as Russ said, the development of the rules in each of these NRDs that we deal with on a regular basis, because they've had IMPs in place for a long time, and as Russ also said, those things may be coming to a NRD near you somewhere. In any event, transfers is kind of a new concept that came in with LB 972 a few years back, and I remember being at one of these then, and one of the speakers was theorizing on what transfers might look like and said, this is just sort of the wild, wild west, because there's really been no market for water in Nebraska, and we don't know how to move it. We don't know what the details are about moving it, and we don't know what it's worth. I represent an irrigation district on the Nebraska-Colorado border, and we run into that problem a lot because there are expectations from the Colorado folks about what they think water's worth under the Colorado legal system, as opposed to what water might be worth in the Nebraska system, and there's a vast difference. What I typically have seen in places like the Central Platte NRD, where moving water around has become a pretty sophisticated set of rules and processes, is that people will value water based on the difference in value of the farmland between it being fully irrigated or partially irrigated and dry, or some degree of dryness. So we're looking at how it affects the fair market value of the land itself, even though that may or may not be a true measure. Let's see. So one of the first questions you have to ask yourself if somebody's coming to you about a transfer is, are we talking about surface water or are we talking about groundwater? Well, why does that matter? Well, as you all know, if you do any water law, there are two systems in Nebraska and different agencies that deal with those issues. So you have to know whose rules apply. So if it's surface water, there may be some NRD involvement, but primarily it's going to involve the DNR. If it involves wells or new wells, decommissioning wells, that sort of thing, you may have involvement of both. Groundwater is typically the NRD's responsibility, and each NRD, if you've not heard this before, I repeat it again, each NRD has their own rules, and every NRD does it differently. One of the speakers yesterday spoke about that and said, you know, the great thing about Nebraska's system is that because we have NRDs with different needs, different hydrogeological features, different agricultural needs, et cetera, we have all these different rules, and it gives us as policymakers an opportunity to think about which of these work and which don't. It's kind of like a grand experiment. So for practitioners, however, those of us who are worried about our malpractice premiums, we have to make sure we read the rules, and we know that the rules of the NRD that we're in are the ones that, you know, we understand and we are going to follow. And in some cases, we have situations where it's kind of a combined project. For instance, some of the NRDs, Central Platte in particular, has done some pretty large augmentation projects involving retiring surface water rights, moving surface water rights around, adding wells, decommissioning wells, that sort of thing. So you sort of have a combination of both agencies involved in those deals, and you have to understand that as you get into them. You know, I had a case, I was thinking about this when we were putting this together. I had a case in the past year or two where I had a client who had a surface water right in an NRD that I had not practiced in before. But I found that the surface water right in that NRD is treated like a groundwater right for purposes of transfers, which I thought was unusual, in that the NRDs simply looked at certified acres. So they required their surface water irrigators to certify acres the same way they did groundwater acres, and then you could pick them up, move them with the condition that, in fact, you decommission, you get rid of the water right, the surface water right, so that nobody could appropriate that water going down the road. Interestingly enough, then, that person was able to sell those certified acres to somebody else and transfer them somewhere else in that NRD. So again, kind of a combined situation. So the next question is, who are your parties? So if you draft contracts for a living, or at least once in a while, hopefully one of the first questions you ask yourself is, who's my client? And who's the person on the other side? And what about them do I need to document appropriately in my documentation? Because, you know, our job here is to make sure that we give everybody the deal that they thought they had. And if we don't document it properly, of course, we're in trouble. In many cases, we're seeing private parties who are who are doing transactions to move water, paper water, from one place to another within NRDs that allow that. So we have private parties, and we have a counterparty there, and we may have a realtor in the middle of that somewhere who's pushing to get that deal done, doesn't always understand water rights very well, and they simply want to close the sale so that they can get their commission. We have sellers who, of course, are interested in getting paid and then interested in not getting sued later. That's important. And then, you know, the other private party who says, I'm paying you $100,000 for this water right, I want some protection. So that I know that if you are in fact retiring your use of water in that particular area that you're saying you're retiring water, you don't go back in later and drill a well, turn on a well, plant a sub-irrigated crop, or do something else that means that that water right, that water use is back in use, and somehow me as a buyer might have a problem with that down the road. And one of the concerns there between private party transfers is this question of how do you protect yourself if you're the buyer? And we run into a lot of resistance with realtors in particular who don't care, and sellers who don't want to be in a situation where the agreement they have, the contract they have, has any teeth in it whatsoever. So when I represent buyers, I'm kind of frustrated sometimes, but that happens. There are 3 handouts up on the website that I've submitted that are not part of this slideshow that have a couple of documents that might be helpful to you if you're doing these. One is kind of a belt and suspenders approach to drafting a purchase agreement, if you're on the buyer's side in particular. There's a lot of stuff in it. Some of it, most of it won't apply to a particular transaction, but it's meant to deal with both private parties, parties that might be public entities in some cases, and also parties that might be industrial. So you have an industrial use that's requiring water. So I'd urge you to take a look at that, and also some of the transfer documentation that we've put up there. There's also an article that I wrote for the Nebraska Lawyer about a year ago that sort of walks through some of these things that make me stay awake at night when I think about these sorts of transactions, and there's a lot more detail than you'll get today. So here's some examples. First one, farmer wants to move groundwater from one parcel to another on the same farm, or on land that farmer owns. That's a lot easier. Did one of those just recently in the Central Platte NRD, and my farmer makes the application. You know, you can go onto the website at Central Platte, at least, go onto the website, and there's a whole set of forms. You pick the one you want, which is the application to move water. You fill that out. Of course, as Russ said, you go have some conversations with your local NRD people, because they'll help you walk through that in most cases. And then the NRD does its job, which is to determine how much consumptive use is allocated to each of these pieces of land, and that's a fairly complicated process, or at least appears to be from the outside. The Coheist model is used in the Central Platte, and based on modeling, they determine what depletion allowances apply, and so each piece of land is given some kind of a value that tells you what does this piece of land turn into if I move it over here. So 16 acres of land right next to the Platte River may turn into 80 acres up in the hills somewhere north of town, north of the river. So it makes a difference that in terms of the way they do that calculation, you want to understand that, and you want to let them go through that process. So anyway, in any event, the farmer-to-farmer deal really only involves the NRD. They'll go through some other the steps that they always go through, which include having a lien search done. And the reason for that is that NRDs are required now by statute. The first version of LB 962 didn't have this lien search in it. It later came along when the bankers woke up to the idea that, gee, if we move the water off of this quarter, we've impaired the value of my security interest on that quarter section. And so they came back and got some legislation passed that requires the NRD to do that search. People need to understand that the search is done for nobody's benefit except the secured parties. So you're not getting a title opinion from the attorney for the NRD. what you're getting is a simple lien search. And if there are parties that hold liens, then those parties will have to sign off on this water transfer before the transfer can take place. So those things happen in the farmer to the same farmer transaction. Farmer buys a water right from another landowner in order to add acres of irrigation. That's what I was just talking about. My client buys 16 acres of retired water rights near the river, and he moves them up into the hills so that he can put a corner system on his center pivot and water his corners. That works nicely, but it's very expensive. The interesting thing about how that transaction tends to work in my part of the country, at least, is that the guy who sells me 16 acres of water doesn't sell me 16 acres of water. He sells me the 80 acres of water that it turned into, and the price is based on that number of acres, not the number that he retires. So that can be a tens of thousands or hundreds of thousands of dollars transaction. That's where I get concerned when I'm representing the buyer. Does that buyer have a remedy if this deal goes south? But same process, basically. You go to the NRD, do the application. NRD works through its processes. They do their paperwork, and then instruments come out, and I'll talk about that in a minute. Another opportunity is an augmentation project. NRDs get involved in doing these things to some degree, and Don and I worked on one for a few years back in which I represented some irrigation companies, and Don represented an NRD that bought those irrigation companies' water rights in some cases or entered into management agreements with them. Those are very interesting transactions, very cutting edge in terms of what they were trying to accomplish. And so far, if you, well, Lyndon was here yesterday talking about how those projects have worked, and they're very, they seem to be very successful for that NRD. But there you've got a whole bunch of different parties that might be involved. You've got the documentation between the parties, the NRD and the districts. You've got the documentation that the NRD normally requires to make some of these things happen. And you might have the DNR involved if, of course, surface water is involved, or if you're moving wells around or something like that. I did, in doing some work recently, I noticed that one of the things that was added to LB 1098 last year was a requirement that if an NRD wants to do an augmentation project, you're now required to hold public hearings. If anybody wasn't doing that before, there is a requirement now since April of 2014. Another example, whoop, how do I back this up? Anybody have any ideas? Back arrow, thank you. Thank you. I was just barely able to get these put together, let alone know how to run it. So another example would be an industrial user that comes to the NRD and says, gosh, we want to build a biodiesel plant or an ethanol plant in your district. In that period of time, right before 2008, when, as one of my clients put it, everybody who has a flat spot thinks we're going to build an ethanol plant here. I was involved in a lot of ethanol development work, and I do work for ethanol companies as well. And of course, in our part of the country, that meant we were dealing with NRDs in many cases that had IMPs or had special rules already in place that said if we're going to put an industrial well in for an industrial use, then we're going to require offsets. And so those developers would go out and try to find some water somewhere that was for sale so that they could move it to their plant site, on paper, of course, and drill a well or two on that site so that they could do the product that they have. Now, just a little plug for the ethanol industry. A lot of people think they use a lot of water, and that's not necessarily true. They use about the same, you know, a 40 million gallon plant uses about the same amount of water as an 18-hole golf course in a year. But they, like everybody else, are using technology to become more efficient, and I think that's going to make a big difference as we go forward. But in any event, I guess my point here on this slide is you need to know what the IMP says and what the NRD's rules say before you get involved in that sort of transaction. And again, one of the documents that's up on the site has language that would be useful in that sort of transaction. Also recognize that there are rules within NRDs about well spacing. There are also statutes about well spacing that require you to get special permission from the DNR if you want to put wells closer together than statutes allow, if you're close to a municipal well, for instance. And there's some statutory language that gives NRDs credit for decreases in consumptive use to the extent that these industrial users can start to reduce their consumptive use. Okay. So documentation, I've covered some of this already. You know you're going to have documentation with the NRD. NRD's rules are going to mostly drive what you do there, although statutory rules will also apply. Because you have sometimes counterparties, then the documentation with your counterparties are important, so there'll be documentation between them. The final step, for no matter whether you do it privately or not, at least from the standpoint of a transaction, is to make sure that the Register of Deeds office has something on file to show that water has been moved from this parcel to this parcel, so that there's record notice out to subsequent purchasers and lien holders or people who want to secure the property that in fact the water rights have been modified. As Russ discussed earlier and I've talked about before, the right to use water in Nebraska is only that. You don't own that water, even if you own the land that overlies the water from a groundwater standpoint, or even if you're adjacent to it on flowing water. So people need to recognize that, again, we're not moving property, we're just moving a right to use the water that belongs to the public by both statute and Constitution. As I look at my notes, I think that's all I have. Are there any questions or questions for any of the rest of us? We may get an early break here, Anthony.
No, we can't have that. I'll ask questions until
You will? Okay.
time. We got CLE credits. I can't.
Oh, okay.
Dealing with Colorado, I don't want to be subject to litigation.
Well, come on, guys.
We've got a couple over here and one here. It's for the audio, the recording.
Thank you. The terminology water rights is what I'd like to have you all address a little bit more. I was not able to be here this morning. I am on Lower Platte South NRD board. And hi, Russ. And I've been so cautious to use the term water rights in relationship to groundwater, and yet that seems to be the terminology that is evolving. And in that case, in Nebraska, how do we differentiate that from surface water rights?
Sure. Since I brought it up, I'll start. The Nebraska law has been clear by case law for a long time, and by implication from statutory and other places, that the right to use water is the right to water is simply a right to use. It's the big lawyer word for that is usufructuary right. It's a right to use only. So I may have a parcel that has groundwater underlying it. That water is not mine. I can't sever it. So and in the article that's up, I talk about that a little bit. That if you had minerals, you had oil, gas, something else that somebody wants under the ground that you own, you could sell that property after severing that mineral right and keep that mineral right and still sell the land to somebody else. You can't do that with water because you don't own that water. What you can do, though, is under our regulatory rules for NRDs, actually move the right to use the water from one place to another. I don't know if that clarifies that for you or not.
It certainly clarifies the law. It's the terminology that still would be confusing for a layperson, I would think. Water right means X number of gallons from a surface irrigator versus something different for a groundwater user.
I would look at water rights just as a generic term. meaning your right to access and make use of those molecules of water. Whether the scope of that right is going to vary pretty dramatically. If it's a surface water right, you get a piece of paper from the DNR, which tells you what your water right is. It gives you a priority date, tells you where you can use it, how much you can use. So that's pretty easy. With respect to groundwater, I think every landowner in Nebraska had a qualified groundwater right prior to LB 962. With the passage of LB 962, that's not always the case, and your ability to access and use groundwater is determined by your local NRD. So your water right, in some instances, is determined by your certified acres. And I oftentimes refer to the water right as just your certified acres. So it's not a term that one size fits all. I think you're going to have to look NRD to NRD to figure out the exact parameters of that water right, if that helps.
Yeah, my question goes to Russ and Don, and both of you implied that there's possible litigation if a variance wasn't granted. You didn't say it quite like that, but what I'm finding at Lower Platte South is we have rules on certification of acres and allocation, and we're now beginning to get applications in for variances, and we're going plowing through those. It is difficult to be consistent, whatever that means, because they're all fact specific. Assuming that we follow the procedures set forth in our own rules on how to determine variances, what can we be looking forward to in terms of grounds for litigation? I don't see a lot there.
Generally, there aren't very good grounds for litigation. But what we found are people will challenge the failure to grant a variance on all sorts of kooky theories. Very few of them are actually valid. On occasion, though, you do have the facts line up in such a way that I think there could be a viable challenge. And for instance, sometimes NRDs just blanket prohibit the drilling of a new well. And a person comes in, seeks a variance for a permit, and has some good facts to demonstrate that that particular location, the groundwater that they intend to access will not impact any surrounding groundwater user or deplete stream flow. And in that instance, I don't think NRDs have the ability to restrict the drilling of a new well. And that would be one basis for a challenge.
Okay, assuming that, well, certain times on the passage of time, you just plain change your mind too. Yeah. And the passage of time may also present slightly different circumstances. So it's something I think NRDs with their new regulations out there on certified acres and on allocations are going to be increasingly confronted with.
As Don was alluding to, there's fact situations where it may be that, for instance, farmer A, B, and C, or golf course A and B got their variance granted, and then golf course C did not. And, you know, whenever there's disagreements, there's usually some way for lawyers to find a way to extract fees from their clients. And as Don had alluded to, you know, it's difficult to overcome the discretion of the NRD. They have a lot of discretion built into statute and into their regs. Courts don't want to be second guessing them because they're the experts within their area. That being said, though, sometimes they're not entities who engage in a quasi-judicial fashion in a regular manner. There's other political subdivisions that do it more and do it better because they do it more. You don't have a board of adjustment. Really, these licenses, at least in regards to groundwater, are more akin to zoning types of restrictions. And there's defined case law and manners for handling those. And the way that the NRDs handle those are not the same as other zoning authorities. There's usually an error hearing, and there's a variance type of hearing. They're two separate paths for review. The NRDs do not have an error hearing. So I think that if you had someone who disagreed with your result on a variance, that doesn't keep them from suing. If there's factual discrepancies amongst the various people who've been granted or who haven't, or if there's some ambiguity within the regulations. Those are both fodder for someone to sue upon. Consistently.
I guess my question's for Dan. I've been wondering this for a while, and I should probably ask you in a smaller forum, but when you grant a certified acre water use permission right transfer, when you're drafting one of those, and now that you have to notify the lien holders, in all likelihood in Nebraska, the lien holder is going to be some huge insurance company in Ohio or a holding company in Texas. And my experience with those entities is if they don't understand something, they just sit on it. And, you know, be it the railroad, be it any large entity, these things are so complex and so hard to understand, even the wording of them. What happens when you send something to Ohio and say, we're doing this transfer? What do you get back? Do they even respond to you?
Yeah, actually, Lash, we could have talked about this over lunch, but I didn't know you were interested in it. That's all right. Typically what happens is that if you are the seller of that water right and you're moving it to somebody else, or you're moving it from one piece of land to the other, that might make it easier depending on which of those two situations you're in. If First National Bank has a security interest on the land that the water is being transferred from, and they also have a security interest on the dry land that's now about to become irrigated land, they don't care, assuming that all things are equal and that the value of that land that the water goes to, it will have a similar increase in value over what was lost on the other piece of ground. It's more problematic if you have a situation where you have a landowner that is selling off water rights and they haven't talked to their banker about it yet. I haven't run into that. That's where the problem lies. But typically, at least in my part of the country, it's been local bankers that have been dealing with that question. So the NRD has a form that it will utilize to have the banker sign off on the transfer before the transfer is approved. And if everybody has had the proper conversation, the landowner will take that form, take it down to the bank, have it signed and notarized, and go back to the NRD's counsel, and that's another thing they can check off their list. So lien search shows there's a lien, they do the form gets signed, and it comes back into the NRD. Then after all that happens, the NRD can approve the transfer and issue the instrument of transfer that they put on the Register of Deeds record to show the transfer on both properties.
So the liens are a lot more local than I thought.
Yeah, we're not talking about, again, you know, if you look at title to the farmland, a lot of times you'll see mineral rights that have been reserved from the 1930s. Some insurance company in Ohio has those still because they had a mortgage on the property in the 30s. But that's not really what we're talking about here. We're only talking about the lender who has secured the security interest by trust deed or mortgage on the real property.
Yeah, I had a question about, okay, so on the hearing process, the NRD hearings, on the enforcement hearing, one of you said that the APA doesn't apply. But then I noticed on another slide that the APA standard of review was applicable on appeal. And I was just curious why that was. Why is it de novo review on the record if
That's a good question, and it's a real oddity, because if you look at the case law, NRDs are not agencies under the APA, but I believe it's 46-750, the statute, says that if you appeal a decision by an NRD, it should follow the APA process.
I was going to ask a question about variances. And I don't know that there's grounds for much litigation, but I think there is. Maybe, and it's interesting to figure out what exactly due process requires in the context of local governments and hearings and variances and things along those lines. But one question that comes to mind is how well wrought is a standard for the issuance of a variance on a particular question? Is it just board can issue a variance if it wants, or is it undue hardship or something along those lines that enables the judiciary to review the question? If if there isn't such a standard, I wonder what your thoughts are on that. And if there is a standard, do you have any examples of those?
I'm not aware of any statutory requirements or any even common law standards. I've told my clients, my NRD clients, that you really ought to conduct these proceedings very much like a standard court proceeding. Consider yourself as bearing the burden of proof as to why you won't grant that variance, and to lay out the factual basis and legal basis for your denial, and then give your opponent, the person who seeks the variance, an equal opportunity to present their facts and evidence and create a record that way. I don't know that it's strictly speaking necessary, but it strikes me as to be the prudent way to approach it.
Is there a standard that they're applying in the course of those proceedings? That is, do the regs include anything on the issuance of variances?
No, generally they just apply their rules on a very hardline stance. Again, it's always fact-based, and I think Larry alluded to it. Facts can change everything, you know, and those rules sometimes, because of the facts, don't make sense, and that's when you'll get the variance granted.
Do you think there's an opportunity, or at least would there be huge resistance to the legislature revisiting the question of natural resources district procedure, and specifically the question of judicial review, to clear up a lot of the uncertainty associated with the applicability of the APA, the non-agency status, local government status of NRDs? Do you think it's, one, a good idea, but two, feasible?
I'll answer the second part of that first, because that's the easy part. If it's got water in it, chances are it's not going to be very popular at the legislature. I'm constantly shocked each year, even the simplest of bills faced opposition if they've got water in them. I think it would be a good idea, actually, to clean up how NRDs ought to engage in these sorts of hearings. I just don't see that as happening anytime soon.
While you're getting up there, on the variance process question reminds me of Spear T Ranch litigation, in that a lot of people don't realize that Spear T Ranch had a deep well on the property that they were not utilizing, but they could utilize. And it turns out that had they gone to the NRD and sought a variance, the NRD very likely would have granted their right to turn on that well and use it, even though they'd gone past their grandfather period of time for certifying acres and so forth. So, I mean, that would have been a use that I thought was would make a difference in the way that litigation might turn out.
I just had a general comment back on the issue of water rights and the definition. I work for the Natural Resource District up in Norfolk. We're late to the party on certification of acres. We're still working on that. There's a general misconception among some landowners that the acres registered to an irrigation well is a property right, is a water right. And the historical use established on the land is oftentimes, sometimes something very different. So just a general comment.
Yeah, and I'll add to that, because I've heard this theory floated a number of times just in the last couple of months, that the correlative rights doctrine still applies absolutely across Nebraska, and I think part of it arises from that same concept. So I've heard landowners say, well, by golly, I'm going to sue the NRD if they don't give me a permit because I've got a correlative right to drill. And I don't think that's the case any longer, and I think that's part of the confusion.
Don or Dan, I don't know which one, maybe both of you, you talk about situations where a bank has a lien on a piece of property and that owner wants to transfer the right to use water to somebody else. So it really turns irrigated land into dry land. And that's what their concern is. How's that any different, and maybe it's because they don't know it, is where you're suffering groundwater depletions, and those depletions get to a point where it's turning irrigated land into dry land.
Well, yeah, I mean, I think this is probably a broader question, Tom, than just my presentation, but that's right. I mean, if you're an attorney representing a bank, if your bank is not paying attention to the depletions in some parts of the state, they may find that the value of their security is substantially diminished. And so that if they did have to take this land by foreclosure, that they would not realize the amount of the loan depending on what they have loaned out. And of course, there's the whole ag lending real estate business, of course, is a whole nother topic, but in that area, because of what happened in the 80s and the economy, the recession that we've had recently, bankers have been much more conservative about their loan-to-value ratios. But nonetheless, that could happen, and they need to pay attention to that before they enter into those transactions. But as somebody mentioned this morning, some NRDs have seen decreases of 120 feet in the past couple of years. That's a big, big drop. And I know it's localized, but if you happen to be the banker that owns the land that overlies that 120-foot drop, that's a big deal.
I think we will dismiss for a break until 3 o'clock, at which time we'll reconvene for ethics. Thank you, gentlemen.